Bismillahirrahmanirrahim. Honorable Usman Sahab, Honorable Shah Sahab, Honorable audience, ladies and gentlemen, Assalamu alaikum. It's indeed a great honor for me to be a speaker at Oxbridge event. It's always a great honor when your own alma mater honors you. The topic that I'll be talking about is up on the slide. It's international obligations on Pakistan. And in this brief presentation, I intend to talk about what obligations the state of Pakistan faces now in 2017. And the way I intend to take this through is that I'll give an overview of what is the nature of those obligations, and then I'll give specific examples, about 16 or 17 examples of those various sets of obligations in various areas, to emphasize the significance of a responsible state that Pakistan needs to evolve as. Let me start by first introducing you to the concept. This phrase, rule of law, is invariably used so frequently that we should uphold the rule of law. A rule of law, what does it really mean? It means that you have to uphold the Constitution of Pakistan, and in addition to the Constitution of Pakistan, there are about 8,000 federal laws made under the Constitution. And then there are about 3,000 plus provincial statutes in Pakistan. So we're talking about 12 to 13,000 federal and provincial laws that need to be implemented across the territories of Pakistan. So that's when the law rules. So although it is often said that the steel frame of the state is the civil servants, I believe the steel frame of the state are the statutes, which manage the state. It's a management tool of the state. You manage the affairs of the state. You bring changes, you bring improvements, you bring in all sorts of restructuring and improvement through changes in the legislation. And the number of laws are up on this slide, about 12,000 plus. So when we say rule of law, we are talking not merely the Constitution, but upholding the rule of law of number of statutes. In addition to rule of law, I submit, includes a package of treaties which the state of Pakistan has ratified. So rule of law should not be confined to the rules made by the state of Pakistan internally, but it should also mean those treaties which the state of Pakistan has ratified. And if it has entered into ratified treaties, it has entered into commitments with the international community, they need to be implemented within the territories of Pakistan. And we'll see some examples of that. So whether they are treaties relating to environment, whether they are treaties relating to cultural property, whether they are treaties relating to countering terrorism, they all need to be implemented within the state of Pakistan, throughout the territories of Pakistan. So when we talk about the rule of law, we should not visualize that international law is not included in it. Often that is how it is visualized locally and domestically, even by the courts. Sometimes the judges think our constitution is supreme, and I keep making a point that yes, it is supreme, but it is a domestic law. And if you have entered into a commitment with an international community about anything which contradicts, then we have to bring an amendment in our laws to bring them in conformity with what we have committed to. So rule of law paradigm should not only include domestic laws, set of laws, the stack of laws, but also the treaties that the state of Pakistan has ratified, and which create specific obligations as well. Now, on whom these obligations apply? When we say the state of Pakistan, what do we really mean? I mean, obligations are state specific, they are not regime specific. When you sign a treaty, it is not its life is not limited to the regime which signs it. It is perpetual. So a treaty obligation is state specific. Once you sign a treaty, it's going to be applicable to anyone. So you don't then after signing or ratifying the treaty, the state of Pakistan, or for that matter any state, has no option, no political option to say we will not comply with it. Either don't sign it. Once you are signing it, then it is obligation. And the obligation to fulfill the obligations of the treaty is on the political governments, whether they are in federal whether they are in the provinces, and whether number 8, it's the executive, judiciary, armed forces, and any other organ of the state, the treaty obligations are an obligation of these integral state institutions as well. So judiciary cannot claim, for example, that we are independent and therefore we will examine our law the way we feel like examining it. Judiciary is independent in the state, but not from the state. From the outside, the judgment of the Supreme Court, the judgment of the High Court is viewed as an act of state. So if there is a judgment which says we grant an injunction against construction of an orange train in Lahore because it is too close to a cultural property called Shalimar Garden, internationally it will be viewed as if the judicial organ of the state of Pakistan has just fulfilled its obligation pursuant to the cultural property. Likewise, if there is a suspected terrorist who is released on bail, the obligation will be on the state of Pakistan that it did not have enough criminal justice system intrinsic strength to bring to justice someone who, in the eyes of an international community, should have been behind the bars. So while the judiciary may view itself to be independent, but as I said, the judgments are also viewed as act of state from the outside. Now, this summarizes when we often say in the public gatherings, we are independent, we are a sovereign nation. Politically, that is rhetorical and it may be considerably correct. But I submit the legal position is that our sovereignty is subject to the treaty commitments that the state has made. So you are sovereign to the extent of the portions of sovereignty that the state of Pakistan in any state has voluntarily surrendered. So when you sign a treaty, what do? You surrender a portion of your sovereignty. So when you sign a treaty regarding overflight rights and aircraft can fly across and use the airspace of Pakistan, you sign the Chicago Convention of 1944. What exactly are you doing? You're surrendering little portion of your sovereign rights in your airspace perpetually to a treaty obligation. So now that sovereignty which you have in air is subject to a legal position. So in other words, what is the nature of obligation on the state of Pakistan that needs to be communicated to the people of Pakistan? Not only to the people of Pakistan, but also to the political parties in Pakistan, to the religious scholars in Pakistan, to everyone who has a stake in figuring out how he wants to react. Now, let me take you to where does international obligations spring from? Where do they come from? Where do they emanate from on the state of Pakistan? First, as you said, as I mentioned, treaties that state signs voluntarily. It voluntarily chooses to surrender its sovereignty to the extent of the treaty commitment. Now, that's treaty, so it's binding obligation. But then there's a state practice that state does. Sometimes state, without signing a treaty, adopts a practice which can have a binding effect on it. So state needs to be watchful. If it is taking a consistent position, for example, relating to a certain legal principle of self-determination, of non-proliferation, in Conference of Disarmament, in UN General Assembly, what is the position that has been taken over a number of years? What is the text of resolution that Pakistan has been endorsing? That evolves a position which can be binding on the state itself. Judicial decisions. Judicial decisions within the state sometimes can be significant, and judicial decisions outside from international forums are also binding on the state of Pakistan. So judicial decisions such as another case, we had this in 1950s when we had the Durand line ambiguity, whether it's an international border or not. So the Supreme Court of Pakistan addressed this issue in a Zewar Khan case. So, and it said there was some importer, Mr. Zewar Khan, he smuggled certain goods from Durand line border and brought them in. He was captured and he was then prosecuted. And he took the plea, I didn't import anything. There's no smuggling on my part because I didn't import because this is not an international border. So the case went up to the Supreme Court of Pakistan. And Supreme Court was invited to address this issue first, whether it is to be qualified as an import or not. From the customer, you know what I'm saying. Whether it qualifies into a definition for smuggling or import or not. And therefore, the court had to address whether Durand line border is an international border or not. So in that case, the Supreme Court of Pakistan then got hold of documentation from the House of Commons, from the practice by the government of Afghanistan, from the practice by other states, and came to a conclusion it is an international border. So a judgment, judicial decision by a domestic court becomes a position. So whenever Pakistan has to clarify anywhere the Durand line is an international border, it presents the Zewar Khan case as a judgment coming out of the judicial court. So legal principle coming up. Likewise, you have international judgments, where if you want to know about the nuclear aspect, then 1996 legal opinion on the legality of nuclear weapons by the International Court of Justice gives you a sense of which direction you need to take your nuclear policy. Because without that judgment analysis, nuclear doctrines can't be evolved. So judicial decisions become important, whether they are coming from international entities or from domestic courts. The fourth box is about international organization resolution. Now this is a very, very interesting development over the last 10 years in particular. International organizations about more than 50,000 in numbers. So they are creation of multilateral treaties. There is what we call multinationals. Multinationals are like ICC and McDonald's who have been registered in one state but have offices elsewhere. But international organizations are creation of multilateral treaties. A treaty creates them between two or more states. So whether it's IAEA, International Atomic Energy Agency, is established by IAEA statute. United Nations is established by a multilateral treaty called the UN Charter. ILO, OPCW, established by Chemical Weapons Convention. There are about 50,000 plus of such treaties, treaty bodies which exist, which have jurisdiction on various aspects of statecraft, who administer law of the sea. Some administer airspace, some administer minerals, some administer trade, some talk about transshipment, and so on and so forth. Those organizations are beginning to create legislation. They are issuing resolutions. They create more encumbrances on the state without the state even knowing it. So, giving you an example, the well-recognized example, the UN Security Council. Security Council was traditionally mandated whenever you have a crisis in the world, then you spring into action under Chapter 7 and address that issue so that the threat to peace is averted. But now the Security Council has started doing legislation. It has come out with so many resolutions on counterterrorism and non-proliferation and so on and so forth, and Al-Qaeda, Taliban in Yemen and everything. The UN Security Council has started giving mandate of legislation. And this is a very unique development. So we need to be aware of the entire stack of laws that are being promulgated by these international organizations under the rubric of various international bodies. But we have a problem in Pakistan recently because of the 18th Amendment. The state ratifies a treaty, but because after 18th Amendment, a lot of things have been devolved to the provincial governments. So the subjects in respect of which we have signed treaties, most of them have gone to the provincial governments. So the compliance is with the provincial government, accountability is with the federal government. So federal government has to face the international community and be accountable for that and find itself into a very difficult situation, while the compliance has to be done at the provincial level. So that if the compliance is uneven, we have a non-compliant state evolutionary process. So therefore, we need to be aware of the complications in that. And in that, there was, in 2013, treaty implementation cells were notified by my ministry when I was there. And the idea of treaty implementation cell was that each province and each provincial assembly should have a treaty implementation cell next to the chief minister, because chief minister is the leader of the house and he can make legislation. So if he is aware of the treaty commitments, he can do legislation at a provincial level for effective implementation of the treaty. So I think there has been some work going on the treaty implementation cells as well. Now let me come to the few examples of international obligations on the state of Pakistan. Obligation to protect foreign investor. Pakistan has signed over 46 bilateral investment treaties. They are called BITs, with other states. And under the bilateral investment treaty, the state of Pakistan has an obligation to facilitate foreign investors, whether we like it or not. There have been situations where we think we have done a wrong deal. It's an unfair deal that we have done. It could have been better negotiated. It could have been much better improved. But all said and done, by virtue of the BIT, we have an obligation to extend protection to the investor. And the whole idea of the BIT was that in 70s, when Usman Saab would know it better than anybody else, when Libya expropriated the oil companies that were there, and then the law of expropriation started growing, that you cannot expropriate. Expropriation at that point in time was understood to mean that you just get hold of a factory and the state has taken it over. But then the definition of expropriation began to expand with case law. And they said even the change of law, which affects the investor's interest, could be viewed as expropriation. It went that far. If you are unable to give protection to the investor in a law and order situation, if his office is hurt, if there's a procession and there are a few stones thrown at his glass and his vehicle breaks up, he can technically sue the state that you are unable to extend protection to me. So it sometimes goes that far. So therefore, right now the government of Pakistan is considering whether it wants to do more bilateral investment treaties or not, given the circumstances that the state is confronted. But nevertheless, as I said, this is an ongoing obligation relating to at least 46 countries. The other example I can give you of an international obligation in the state of Pakistan is an obligation as a low riparian. You see, we normally talk about Indus Water Treaty, and we invariably think that's the only law applicable to the state of Pakistan. But I submit it's not. The treaty is just one illegal instrument, bilateral instrument. The international law relating to water has been developing much beyond the treaty, much beyond the Indus Water Treaty. And if you look at about 187 treaties between African countries, upper and lower riparian, they have developed legal principles over a period of time. Some of them have been embodied in multilateral treaties of 92 and 97 conventions. One of the major principles which has evolved is that lower riparian cannot just be dismissive about his own obligation to preserve water. Lower riparian, while he points fingers towards the upper riparian, that he should act as a trustee for my water resource and hold it. But at the same time, the law says, now the international law jurisprudence on water law says that the lower riparian has the responsibility to also preserve water and make every effort, whether it needs to make pondages, dams, reservoirs, or whatever. Then we have also now recently entered into the Hague Convention on Child Abduction of 1980. Now this is a convention in which, in case of divided families or in case of issues where a Pakistani couple goes to London, they have a child, he's brought back, so what do you do now, or in Japan or elsewhere. So there was an issue of transnational transfer of children which was creating a lot of issues vis-a-vis individual families and point of concern. So Pakistan has just ratified the Hague Convention on Child Abduction. Now by virtue of that, we have an obligation to prevent transnational child abduction. Again, a unique area. The idea of this very diverse example is to give you a spectrum, the wide spectrum of obligations. So we have done this, and this now creates an obligation that we need to notify a central authority. I believe we have notified a central authority. Provincial authorities need to be notified. Guardian and wards, courts who have the custody of the children need to be trained, but in the event of requests for children, you need to do it, and that's by virtue of the 1980 convention that the state has signed. So it is voluntarily signed, now it needs to perform that obligation. Then is the area of intellectual property. My senior partner Majid Bashir specializes in this area. Intellectual property, we have an obligation to protect it. Intellectual property of anyone, including ourselves. What is intellectual property? In summary, it really means the property of your intellect. Whatever you think, your mental product, your invention, your idea, your thesis, your innovation, all that can be registered, can be documented as a copyright, as a patent, as a design, and then it is stand protected. Now you are responsible because it's my product. If I have patented something, it's my product. So I am entitled to receive the benefit of that because it's my intellect's property. Whether it's my book, it's my poem, it's my article, it's my thesis, I am entitled to the protection of its against misuse. It's my song, I'm a singer, I'm entitled to the protection. So while I have to accord protection to the other designs and logos of other companies which are internationally protected. I can also make an effort to do my own. So we have intellectual property organization in Pakistan which is supposed to register whatever comes out of the invention, and we can proceed with that. So this is a very important obligation because it creates, Pakistan has been on the watch list of the US government because of the intellectual property rights. We have made some legislation, some more is coming out, but that needs to be addressed. Obligation to prevent proliferation of weapons of mass destruction. For nuclear weapons, we have the UN Resolution 1540 in 2004. I mean, because this resolution was on creating an obligation relating to proliferation. And then we have Chemical Weapons Convention and Biological Weapons Convention. In case of chemical weapons, all movement of chemicals inside Pakistan has to be accounted for. So whatever moves in drums, in trucks, whether it is imported from Karachi and is going up to Misrisha or going up to a place in Peshawar or being exported, you need to document it, present it to a central authority in Islamabad. The central authority presents it in Hague in OPCW, which has a complete framework that which chemical is moving where, so as they are accounted for. So that's the nature of comprehensive regime, comprehensive obligation that the state has to incur by virtue of this. Same is the case with Bioweapons Convention. So these obligations are specific, implementable, measurable, and they create issues for Pakistan if you have non-compliant with them. Number 6 is obligation to protect cultural heritage. Why? Because cultural heritage does not belong to a country. It's a common heritage of mankind, and under UNESCO framework, you make a declaration, this site is a common heritage. It needs to be preserved for generations to come. So then it is entitled to extraordinary protection. And if you remember the Bamiyan statues, when they were destroyed, there was an outcry. And if you read the UN resolution issued pursuant to the Bamiyan statute, it actually talked about cultural property convention, that it constitutes a gross violation of a property which is supposed to be preserved. So we have ratified several conventions. I won't go into that. So whether it's Taxila sites, whether they are Shahi Masjid or Shalimar Gardens or anywhere else, we have an obligation to protect them. Number 8, and these are World Heritage, there are quite a few of them in Pakistan that are entitled to protection. So if there is defacing of them, we'll be viewed as defaulting in our obligation. Obligation to protect wildlife in Pakistan. Again, it's an obligation which is coming from various conventions. I don't need to go through the names of these conventions, but more or less they talk about that the state has an obligation to prevent illegal trade in wildlife. The wildlife trade is the second largest illicit trade in the world. Second largest, I'm told. The turtles from Pakistan are being smuggled in Far East, and they are caught at the airports and sometimes in Karachi Harbour as well, where they are used for food and so on and so forth. So the trophy hunting concept. The concept of trophy hunting is a preservation measure, conservation measure. And you do that pursuant to a convention framework. So the obligation is again very explicit in terms of what we need to do. Likewise, environment. There are several conventions, and the recent one is the Framework Convention, which was done recently. Pakistan ratified it, and then after that, Pakistan made legislation for implementation of the convention. So Pakistan is one of the few countries which made a fast-track legislation for implementation, so the billion tree and other things will be viewed as implementing measures for that. Number 12 is obligation towards the refugees. Any state has an obligation when refugees enter and they are fleeing for their life and they are being persecuted in another country. The country where they come in has a duty to receive them. But that duty is not indefinite. That duty is subject to improvement in law and order conditions in the country of origin. And then that duty comes to an end. If conditions improve, then the refugees need to go back. So the obligations on Pakistan will be viewed in terms of international convention relating to refugees, although Pakistan may not have ratified it, but in terms of customary norm. 13 is obligations to prevent money laundering. And why is this obligation coming? Where is this coming from? Financial Action Task Force, Asia Pacific Group, UN Security Council Resolution 1647. What it says is that you have an obligation to prevent money laundering. What is money laundering? Money laundering is if the money is originating what are leading to at least 40 listed crimes. They are called predicate offences. And they are murder, kidnapping, corruption, terrorism, and host of other offences. So if the money that is found travelling in your account or elsewhere in a transaction, if that money is linked with any crime, and as I said, FATF says they are list of crimes which are called predicate offences, so then it becomes money laundering itself. So obligation to prevent money laundering, and for that again Pakistan enacted legislation 2010, anti-money laundering law, FIU unit, so on and so forth. An effort is being made, but there's still much that needs to be done. So when Pakistan is judged on the touchstone of all these, they refer specifically to all these conventions to say Pakistan needs to be compliant with them. 14, obligations to improve conditions of labour coming out of ILO conventions, Child Right Convention. International Labour Organization keeps creating various conventions, guidelines and so on and so forth to improve the conditions of those who are defined as labour under the convention. So there continues to be an obligation, and under ILO hearings you have these references coming out of conventions that the state has ratified. 15, obligations to counter terrorism. We have an obligation under international law to counter terrorism as a state of Pakistan, apart from the fact, and amongst international law are these three sets of resolutions. People at the back may not be watching it clearly, but let me give you. The first string is 1373, counter-terrorism. Second box is 1267, Al-Qaeda Taliban. Third one is 1540, non-proliferation. And if you look at it, you will find that there are three committees made under each of these resolutions, which are supposed to monitor the implementation of what the contents and obligations of these resolutions are. So if there is a committee under CTC, which is under 1373, it receives annual reports. Every state in the world, including the state of Pakistan, has an obligation to submit annual reports to all these three committees. What measures that state has undertaken over a period of 1 year to fulfill its obligation under 1373 and 1267. And not only is this substantive track, but then after that about 35 set of individual Chapter 7 resolutions have been issued by the UNSC, which further explain those obligations, which further streamline those obligations. For example, in 1267 Al-Qaeda Taliban, they say anyone who is a member of Al-Qaeda or associate of Al-Qaeda notified. So there is a list of notified member under 1267 being maintained. 400 plus entries are there, individuals and entities. So if someone has an objection that you have put my name wrongly, I am not an associate of Al-Qaeda Taliban, then he is given an option to apply to an ombudsman established pursuant to another resolution under 1267, where he is supposed to present his appeal and say, you have wrongly put me there, and my reasons are as follows. So then there is an adjudication process. So hence, this regime has been unfolding gradually through various, one resolution after another, and now they have become mini conventions. You don't require convention on terrorism. You have these UNSC legislative regimes which now have created multiple obligations on each state, particularly Pakistan, because we are facing these threats in a big way. Similarly, 1540 committee, what steps the state has done in terms of preventing any possibility of non-proliferation and so on and so forth. Countering terrorism, ladies and gentlemen, means disabling a terrorist through police action, military action, prosecution or conviction, and de-radicalization or winning back. Because as I say, countering terrorism does not mean you need to kill a terrorist always. If it's a military compulsion, then fine. I mean, if he's attacking you, he's firing at you, and you are in a combat zone, that explains it better. But if you are able to identify, then you need to de-rad him. You need to win him back. What do I mean by winning back? Winning back means reviving his loyalty towards the state of Pakistan or any state. You know, we have Article 5 in our Constitution which says everyone is to extend loyalty and obedience to the Constitution of Pakistan. Now if someone says, I don't want this Constitution, I want to have my own nizam, I want to have my own environment here. What is he saying? He's basically defying Article 5. He's withdrawing his loyalty, whether it is doing it through a fatwa or a speech or whatever. If he's saying that, he's actually defying his loyalty. So when he's doing that, you need to win him back. You need to make him understand that, look, your constitution says this, which means you need to submit to the rule of law of the state. Those 12,000 laws, you are bound by them. Whether those laws says that in the event of a green belt, you're not supposed to do any activity except the green belt, that's a law. You need to honor it. If the law says anything, you need to honor that law. So winning back means explaining the state's perspective to the people who have been lost to a different narrative. And I believe it is doable. Because if one person can radicalize someone with a half-an-hour speech, the state should be determined to put its resources together to win him back through a counter-narrative. And I believe next one might... but this puts the state in a sense of challenge, and that's why the state is sweating here in this cartoon. But on one hand, it has these obligations to counter terrorism, 1373 and 1267. The international community is telling the state, counter terrorism. You have a duty to make sure they don't exist. You have a duty to make sure you declare the safe havens. On the other hand, the state has an obligation to uphold human rights framework, because that too it has ratified. So state has ratified International Covenant on Civil and Political Rights, which is the most important human rights treaty, against which Pakistan and every other state is evaluated. So your universal periodic review is done pursuant to that. Convention Against Torture, Universal Declaration of Human Rights, and so on and so forth. So the state has to balance this, and it is this balancing act which is now the real challenge for not only the state of Pakistan, but all the states in the world which are facing issues of radicalization. Let me also then, number 16 is obligation to develop a counter-narrative. Most recently, this May 2017, Security Council created an obligation to develop a counter-narrative. Not many people know about this. 2354 resolution came, and it created an obligation on the member states. You have a duty to develop a counter-narrative. It's not merely a political choice, it's now a legal compulsion. And which further means that you need to work, research, invest, undertake research, get funding, donor funding, your own generation, put scholars who could work on this. And when you have that, then you are able to go into reforms, whether it's madrasa, revival economic activity, economic zones, be that for social media, and then what's your plan as part of that for those who are with the state when you are in the prison, whether in a pre-conviction mode or a post-conviction mode, you are with the state as a detainee, whatsoever capacity you might have. And there are thousands of them throughout the jails and prisons all over the country. What is the state doing vis-a-vis them? Is there a strategy to win them back? What kind of literature are they reading? What kind of religious scholars are they listening to while they are in the prison? That's where they have in complete control of the state. But state needs to think about it, because now it's an obligation. So whether we have an 18th Amendment issue that religious education is devolved at a provincial level, that apart, the obligation is now actually in the Chapter 7. 17 is to obligation for transnational law enforcement cooperation. This is very interesting. Under 1373 UN law, there's an obligation to counter terrorism and also extend cooperation with each other. And we haven't done much on that. Pakistan and even the regional countries, we should have by now, between Pakistan and India, Pakistan and Afghanistan, Pakistan and Iran, we should have had mutual legal assistance legal framework. We sometimes do have a spontaneous meetings in Kabul and Delhi or whatever to exchange intelligence-based information. But I submit that's not sufficient to bring people to justice. You need to have a legal conveyor belt of international law where you could bring and exchange admissible evidence with each other. So instead of giving 75 names, for example, the US government could argue, well, we could give you more cogent evidence to bring them to justice. Or if we have names on the other side, we could give those names with some evidence, intercepts and so on and so forth, to build an argument and bring them to justice, as in the case may be. So likewise, whether it's Mumbai, whether it's Pathankot, we still need to have a fast-track legal conveyor belt vis-a-vis the country. So there's an obligation for transnational law enforcement cooperation that, in my view, the countries in the region are not fulfilling. And finally, as I said, the obligation to DRAD was recently I was looking at this work by Singapore think tank, and they came out with this. Some of you may not be seeing, but let me see. They're just saying that there's a serious threat now of Daesh, of radical views in countries like Indonesia and Singapore and several other countries, and the threat could be watched in Bangladesh, there could be some footprints in India, there are schools of thought there and elsewhere. And if we have that, there's an obligation, as I said, to bring them to justice. So I will come towards the conclusion now, and the conclusion would be that we need to focus on identifying the obligations of law that the state of Pakistan faces. We need to understand that. Now, this should ideally be the job description of the government. The government, the parliament, the executive branch of the state needs to make its own people, its own self first aware that these are the obligations. Sometimes the parliamentarians are not well aware. There is a need for translation. We don't have that. So, what you introduced me that I chair the Research Society of International Law, that's a private initiative that I took when I came back from Cambridge. And when I was in Cambridge, that's where I was studying with some of the top international law names, and they inspired me. And I thought that when I go back to Pakistan, I'll set up a research think tank. I had no resources. I started off as a lawyer with 4 lawyers in one room. And gradually, when I was able to have my own building, about 10 years of practice, I donated the top floor to the research think tank of international law, which is called the Research Society of International Law. We now have a branch in Islamabad as well. And the vision of RSIL was very simple: to build capacity to uphold the rule of law and help Pakistan to become stable, prosperous, and a responsible state. On the right side is the photo image of the profile which was submitted to the Registrar of Companies for registration, which was hand-typed by me in 1993. And the idea was that we need to work on these issues. And I believe that by virtue of some work that we have done at RSIL and its related and its team, which has come up, a team of young lawyers, which is now growing. We were just doing work with LUMS, we were doing work with judicial academies, and this team is now growing and is beginning to develop better understanding of that. But much more needs to be done, because Pakistan's obligations are so many. So I believe that this session will also go down to cover that mileage of awareness in Pakistan. I thank you once again for the time that you've given to me. It's been a privilege.
We can now have questions from the floor. Please be brief in asking your questions so that other people have an opportunity to. Please.
Soofi Saab, thank you. That was very educative. Can you tell me how many member states are there which are members of the United Nations?
All of them are the members. All the states are the members of the United Nations.
How many are there in number?
I don't know the count. 193, 193.
193. And what are the total number of states in the world today?
About 200. I'm not too sure.
Actually, not sure. Does anybody else know it?
210, 200, more than 200.
Now, Soofi Saab, is there a obligation of these member states to adhere to a certain level of governance? And can that be enforced by these international conventions?
Like what? You have a specific example that you have in mind. Level of governance. Sorry, level of governance means
good governance, where you have justice, where you have human rights, where you have protection of wildlife, where you don't allow people like what is happening the last 3 weeks between Islamabad and Rawalpindi.
The obligation is there under international law that you have to ensure social justice within your state, and that implies it doesn't prescribe a particular mode of governance, but it suggests you should have good governance and you should have equality and justice and other things, and that is so provided in several treaties, including ICCPR. So that you have to adhere to it.
Can this be enforced by the international community?
Well,
On a sovereign state or a member state?
there are areas of law which need to be self-executed. This is one area which should be self-executed. But if the outcome of lack of governance is anarchy, or the outcome is where you have terrorism or a gross violation of human rights, then another set of doctrines kick in. They are called R2P, responsibility to protect obligations. Slightly controversial, but nevertheless that's a separate doctrine which has been worked on by the UN Secretary General and by the panel, that there could be circumstances in which intervention may be legitimate inside the state to protect certain issues.
My other question is, what is the definition of a failed state and a rogue state?
They are political terms, they are not legal terms. So it's a, and politically it becomes an issue of perception. But as long as the state is honoring its obligations and is able to present its case to international community, then it can't be viewed as a rogue state or a failed state.
So we are paying lip service to a lot of these promises that we made to the international community, but we are not adhering to them.
I'm slightly beg to differ. I think we are making efforts in a lot of areas to fulfill the commitment that we have made, and I've given you kind of a menu of a wide variety of obligations. There are specific steps being taken, whether it's cultural property, notifications being issued, courts coming into play. We were in Supreme Court a couple of weeks back where the Magla Hills was getting protected and we were being asked to draw a specific map based on law.
I'll quote an example. Like we are signatory to the protection of the Obara Bustard, and our foreign service has declared that killing the Obara Bustard is a pillar of our foreign policy.
Yeah, that's a political statement, but let me give you a legal proposition on that. The legal proposition is that Obara Bustard hunting is permissible. It is in a yellow zone or something, not in a prohibited zone completely. But you need to have a limited permit issued for that. Up to 100 Habaras can be hunted in one season by people who are given. The problem is that even if you want to ban, you can't ban because there's a bilateral obligation. The letters that have been issued to the Middle Eastern states by the state of Pakistan have a treaty obligation. Sometimes if you look at the definition of a treaty, it talks about even exchange of correspondence constitutes a treaty obligation. So once you write a letter, which you have written, inviting them and giving them certain specified and notified areas to hunt, you have already made a bilateral commitment. So you need to first bilaterally agree not to hunt and then you can. Otherwise, if you need to hunt, then you have to give them about 100 permits, I believe, under the Wildlife Act.
We have agreed to that?
We have agreed to that.
Thank you.
Gilgit-Baltistan and the CPAC thing, because the region is in the spotlight and there are some international and national obligations involved. You know that Gilgit-Baltistan doesn't have any representation in the parliament, so they're not part of the constitution of Pakistan. And there's a UNSC resolution governing the status of Gilgit-Baltistan in some way. You know, can Pakistan actually tax that region? You know, we have been struggling to basically raise funds for major projects in that you know, that area because of the undefined you know, status. I mean, are they international, according to international conventions and obligations, can they actually tax a region where they have no representation at all in the policy-making forum or legal legislative forums?
That remains a political issue. The other issue is that of the title of a territory vis-a-vis the state. Now, in case of title, you have, if you look at Article 2, I believe, or 3, relating to state of territories of Pakistan, there is our article which says any other territory that Pakistan controls through legislation. So, in other words, if you are making Gilgit-Baltistan legal structure that the way it exists right now, you have claimed the title by virtue of that law and linked the title with the constitution, notwithstanding the controversy associated with the UN resolution. Now, the UN resolution is not specific about Gilgit-Baltistan, by the way. There are 15 resolutions of UNSC. And in fact, one argument is that portions which are related to Gilgit-Baltistan have been excluded from the domain of the plebiscite. if you look at the correspondence, before which the UN resolution was triggered, there were an argument being raised about excluding it because the controversies were confined to this, and then this territory was also subject to some accession instruments as well. So Pakistan, and then in addition to that, if you look at my second box on the third or fourth slide, state practice, treaties, state practice of Pakistan. The control by Pakistan, even if it is argued that Pakistan's title may be tentative, the control by the state of Pakistan over this terrain has been admitted through state practice for a longer period of time than any other issues. The only controversy has begun now. The little bit of reservation that has come up has cropped up now with the CPEC forests. Earlier, the title acceptability, if you look at the documents, if you look at state practice of India as well, you will find hardly one or two concerns being raised. Pakistan, for example, has been raising these concerns on the Kashmir side very often. So I think by virtue of the law of prescription, we go down into a lot of detail on that if you want me to at some point. But we don't have an issue of title, and that's what no one has been able to establish that we don't have a title. The word politically used, it's a controversial area, but that's neither here nor there. How exactly it's controversial, no one has been able to explain. So I think those who wants to fund, that's their political choice to make a determination, but from a constitutional point of view, even in the judgment of the Supreme Court by Justice Ajmal Mian, he said more or less what I am telling you. But he did recommend that you need to give improved rights to these people. So involve them, so make some suitable changes so their rights are addressed to the constitutional machinery which is available to the entire country as well.
The first one is that we seem to lose a lot of cases in arbitration and in the International Court of Justice. Now apparently there could be three reasons for it. One is executive indifference in taking preventive measures. Two, signing of contracts which are favorable to the other party for reasons that are not specified but which are evident. And three, very poor selection sometimes of people to represent us in these forums based more on nepotism than the merit of the concerned person. This is question number one. The second one is about the action taken by the international powers that be and the other agencies on a very selective enforcement of some of the provisions of these treaties in only some countries, and the rest are not touched by them at all, either through sanctions or whatever. Thank you, sir. And we have learned a great deal from it. And the simple reason is that a lot of the things have evolved a long time after some of us had read a little global law. Thank you.
Very, very grateful for your appreciation. I think on the first part you've said more or less yourself that why we lose. To begin with, contesting, when someone takes a case to an international court, it's the failure of the management of the state. It's an investor who has chosen to invest. Now he's dissatisfied so much, he's put off so much, that he has chosen to go to an international court. What does it really mean? It means the state apparatus could not provide him various options of mediation, negotiation, and he was desperate. In all these cases, except the ICJ cases, in all these cases of international arbitrations, the people who have gone to arbitrations were trying to knock at every door to find a resolution. And they were pretty flexible at that point in time, saying we are prepared to renegotiate, but let's proceed further, let's not waste time. And the ability of the people in the government to sit for negotiations was, and one reason I think is the issue of indemnity of a civil servant. It's a completely different thing I'm talking about, but you know, when you have an indemnity as a civil servant, your ability to take bold decisions improves a lot. Because every decision that you take, every initiative that you take as an individual, as a civil servant, is technically can be branded as a misuse of authority. So unless you are protected by law, that good faith actions will not be probed into, will not be inquired into by NAB or FIA, etc., only then you will take those bold decisions. And if you are worried about that, you will go into executive deliberate paralysis. You will say, I'm not going to take any action. Now when the civil servant doesn't take an action, then the state machinery doesn't function. It's at the end of the day the civil servants whose note matters, whose final views matters. He signs an agreement with a private investor. So if a private investor wants to renegotiate, want to resettle the terms, the civil servant, on the other, whether it's a deputy secretary or a chief secretary or a federal secretary, is reluctant. And I've seen this over and over again. So hence, the case gradually sips into an international arbitration. And it's a very reluctant choice by the investor in 9 out of 10 cases. So I think there should be a window of option negotiations available, let's say in the Board of Investment. Under the Board of Investment statute, there's an option for mediation. Now you have 2017 Mediation Act, which has come by the federal government. And that federal government act says you can actually mediate these matters. So if you go into that route, you might actually find a dramatic decrease in going to these forums. The second issue that I wish to, about the selective cases of violations of international law. But by the way, on the ICJ cases, we have a different perspective. In the ICJ, we have strategic issues. So sometimes you need to contest them. Case in point 2, RMI case, Republic of Marshall Islands files a case against India, Pakistan, UK, and other nuclear weapon states, seeking a direction from the ICJ that they should roll back their nuclear assets after entering into negotiations pursuant to Article 6 of the Non-Proliferation Treaty, which negotiate for disarmament. So, and they say, now you need to do this. So, I represented Pakistan in that case, and we filed a reply saying that Republic of Marshall Islands has no dispute with us, and we questioned the legality of dispute. Why are they coming against us? And so on and so forth. We want to go into this and that. And eventually the case was dismissed. The case was dismissed. This was 2016 early. We now have a Yadav case. Again, the Yadav case, there is a strategic aspect to it, because what Mr. Yadav has volunteered in his statement under section 161 before the magistrate in under 164, he has named people, that Indian government officials of the security establishment as X, Y, Z. He has actually named 11 to 12 people, if I'm right. So when he says, I'm here because they asked me to do this, and I was asked to do this, this, and this, so the government of Pakistan then writes a letter to the government of India that we need to have the statements taken of these people who have been named by Mr. Yadav. So the investigation is ongoing, and that is the letter. I'm basing this information based on what has been submitted by India in annexures to his reply in the ICJ document. It's on the web. So letter of assistance from Pakistan asking this is on the web, and India's response on that is also on the web. Now this is a strategic issue. That is why I said that you need to look at a regional level, a possibility of a legal diplomacy. After all, you need to find a resolution of these. You just can't go on. So resolution is a legal framework for that. So I'll stop here. Sorry, the second part of your question is that whether international law is selectively enforced. Yes, perhaps yes, political choices are there. Real politics is there. I was speaking more as a lawyer, which is very legalistic in nature, and international relations is not my area of strength, but yes, I agree with you. It is selectively enforced. Now we have a new term which has been coined by the American analyst. They called it lawfare. There used to be warfare, and now there's this term called lawfare, that you use law. This is by David Kennedy in Harvard Law School. And this, he's an expert on international law, and he coined this phrase in one of his writings. Lawfare is now something which is being utilized. You use international law instruments to put pressure on states and so on and so forth. So we need to be prepared for that. So what you are saying, we not only need lawyers to work on the commercial cases which handle the arbitration, we also need to work on young legal community in particular, which can work on these aspects of understanding the obligations, commitments, and so on and so forth.
Thank you, sir.
When I was coming for this lecture, I thought that it's going to be all legal terms and it's going to be a real boring one. But let me tell you that it was very informative and very interesting and very simple. I really enjoyed listening to everything that you explained. Sir, I came from PWD. It took me almost 2.5 hours, which is normally half an hour drive from that area entering in Islamabad. So I won't speak of the international law, but I need to know that if the government is reluctant to take any kind of action and the masses are facing severe problems because of that for a very long period of time. So in that situation, what can be done when the government is not taking any action and few people just make a city hostage for quite some time. And my second question is regarding the money laundering cases. I'm a bit confused. We were reading and listening a lot about the Pakistani international treaty, and because the media is not very vocal about it. So I need to know that what action was taken about that person which had many solid and strong points of money laundering.
Which person are you talking
I'm talking about Mr. Azad. So I need to know that what action Pakistani government can take against him. I'm sorry, I didn't read anything about the final decision, so if you could help me with that. Thank you.
I think what the state is doing is struggling to negotiate so that they don't have a showdown the way they had it twice. Apart from the political consequences of that, it becomes difficult for the state to internally explain. You had the Lal Masjid episode, again it was a law and order situation. You utilized the legal instruments of section 121 of the Criminal Procedure Code of commissioning armed forces in aid of civil power. The Supreme Court completely misread that, completely was not able to understand it in a conflict zone, what kind. But Supreme Court has matured over a period of time. So when it started with the Lal Masjid assessment, I think it's 2004 or 5, it said it's a murder by the state functionaries. But as Supreme Court was more acclimatized to cases coming up to it of terrorists from various jurisdictions, various high courts, it began to look at things more differently. And now it has come to a point that in military courts case, the Supreme Court judges came to a conclusion that you are facing an internal threat of war. It's a very, very important judicial finding from an international law point of view. You are now in an exception zone, that now you can derogate from enforcement of fundamental right. That's what effectively the Supreme Court was actually saying. And Justice Azmat Saeed and Justice Umar Bandial's views, separate notes that are annexed to that, I would suggest you take a look at them. Very, very informative in terms of applicable laws. And they actually say the law of conflict now begins to apply. There's a law of peace and then there's a law of conflict. When you have a conflict environment, then that conflict law becomes applicable, in which you have a license to even take life. In human rights law, you don't have a right to take life. But in a law of conflict, you have a license to subject to certain prerequisites. So the Supreme Court came to this conclusion. So, and if you look at which organ has now stepped in, yesterday or yesterday, Qazi Faizi, Supreme Court of Pakistan. The Supreme Court has developed, in my assessment, much better clarity on the legal aspects of this issue as of now, more than the executive branch at the moment. So I think it's a very interesting development. Let's see what this is Qazi Faizi. So I think he might be listening to this tomorrow or day after tomorrow.
I don't know, another 2 weeks. No more 2 weeks.
Yeah, but I'm not too sure on that. But I think the Supreme Court is taking notice. On your money laundering thing, money laundering has been a very complex issue for all of us. Individually, the amount that you send for admissions of your children sometimes be branded. You're questioned for that. The bankers come to you. You scratch your head and start wondering what the hell are you talking here? But the law of money laundering creates this kind of a noise because it's become so noisy for the whole country that they really need to. They have educated as well people as well. We talk about, because in the basket of predicate offence, tax evasion wasn't there initially. So, and I remember I was part of that process of drafting of law, that tax evasion wasn't there. So if you are evading a tax, it's an offence under the tax law, it's not viewed as money laundering. But now recently, they suddenly start saying it's money laundering. So you bring into the basket another set of laws that weren't there initially. So if you look at those issues where money laundering, if you're exploring an asset of someone who is prior to this, then the different law will apply in my assessment as opposed to the present law. In case of Altaf Hussain or anybody, no state permits anyone to use his state for committing violence or for inciting violence. The allegation against Mr. Altaf is incitement of violence. And the money that is coming to him or he's been going around is difficult to explain. There are certain judicial extracts of what exactly has he done. For example, there is a judgment of the Supreme Court of Pakistan by Justice Iftihar Chaudhary, in which he documents some transactions, he actually documents use of training and so on and so forth. I believe now one of the persons has engaged a legal team in England, and probably the Crown Prosecution Service might be looking into it more deeply to make an assessment. So I don't know what's exactly happening to that case, but if they're able to link up the money which is with him with any of the crime, 40 listed crimes, theft, kidnapping, hatta, etc., then he has a difficult situation to face.
Issue of indemnity for the civil servant. I think it's not so simple that indemnity would strengthen the hands of the civil servant. We should go before the issue, that is when the contract is being signed. At times it is in the interest of the foreign company that the litigation or the legal side is in their country or in an international law. So that is where there is a judgment call on part of the person signing on behalf of government of Pakistan, whether it is in our interest or in the interest or equal. This is one point. The other point is of the state giving sovereign guarantee to a private company, which I believe has happened repeatedly in the CPEC deals. Your comments on it?
At the time when the negotiations are undertaken, that is a point when you need to have your right negotiation skills and legal input be taken as to what venue suits you, what applicable law suits you. Often arbitrators or often the investors don't agree readily that they would be prepared to do arbitration in Pakistan unless you have a mechanism. You can convince them and they can be convinced as well. So I agree, but as long as the civil servant has written in his notes that these are the justifications for which I agree and had to concede, they were not agreeing, we wanted to invest, etc., etc. But that is the point where the top quality input needs to be taken when you are at the stage of negotiations of that agreement. And there are lots of lapses recorded and known in that at that time as well. The sovereign guarantees to the private companies in principle should be avoided, because the state is not supposed to make itself available for a sovereign guarantee to a private entity. It can at best do it to another state, but that too it does in a very limited circumstances. So that creates an encumbrance on the asset base of the states, whether in Pakistan or abroad. And you never know, private contracts can turn out to be ugly. You may be into a disadvantageous position tomorrow, so how would you... So that certainly, my personal view is a sovereign guarantee needs to be avoided. You can give guarantee of receivables of a certain period, I am prepared to live with that. Receivables of certain project which is ongoing, some cash flow which is coming out from somewhere, you can put a lien on that. But sovereign guarantee is a very, very serious matter. So I am in agreement with you on this.
First of all, I would like to appreciate Oxford and Cambridge Society and especially Shahullah Khan Sahab for introducing such a jewel, diamond among us, who has presented such a nice presentation today. Great appreciation and big round of applause for Shahullah Khan Sahab. And this is finest.
Actually, we owe it to our president, not to me. Thank you.
My question is, taking benefit of your presence, like you have pointed out several resolutions on human rights and other. What about Kashmir issue? There are several human rights resolutions of security, UN Security Council, but we are observing that for the last 70 years, UN Security Council has not been implemented. What is the future? How we can get it resolved? The atrocities of Kashmiris are ahead of everybody. Thank you.
Thank you very much. It's been 70 years with this issue. I think as a lawyer, if I were to contest the Kashmir case, I think we have an excellent case regarding Kashmir. Resolutions are there, other legal materials is there. But you need to also use law for creative solutions. Not for stalemate only, we use it for presenting our position and improving our positions. But we can also use law and international law for creative solutions in matters of this nature. just for an example, you could have a team of 2 lawyers from Indian and Pakistani side working on a non-attributable basis in Geneva for a few months and hammering out maybe a proposed settlement treaty. Maybe. Just a thought. And maybe without attribution it could be presented to both the states and the Kashmiris. But here's a way forward. Because what we do, I'm also a commercial lawyer. I have a law firm with offices in Lahore and Islamabad. And commercial deals when our clients, they instruct us. Look, we are interested in doing this. Hammer out a legal instrument, a set of legal instruments that we can achieve what we want to do. So as lawyers, we do that and then we present those solutions to the corporate heads of both sides. And we say, sir, one is this option, second is the third. So they have something in concrete in front of them to look at. Now in case of Kashmir, no one has presented a concrete, tangible solution to look at. People have just been talking in terms of generalities. I can also talk about generalities, but I personally think that if you want to move forward on that, let's put something on the table, as I said, on a non-attributable basis, and see where it goes from there. Involve Kashmiris in that process. They should be part of that. Things can be resolved. We have, what our legal strength gives us is that we will not be in a position to yield beyond a certain point. We are good at that. India has certain points. And I think we need to also bring to the notice of the Indians and the international community that now the Indian courts themselves are saying it's a disputed area. So it needs to be addressed. The Jammu and Kashmir High Court recently, two different judgments, has said someone was attempting to scrap Article 370 and brought a challenge to Article 370 before Jammu and Kashmir High Courts. And the High Court said no. It has to be, if you need to scrap it, it has to be done by creating a constituent assembly. It can't be done, therefore 370 stands, which basically means issue is controversial. So in other words, the political position of Modi's government is in conflict with the constitutional position of the Indian constitution. So if I frame my proposition like this and present it to the international community that look, I want to sort this out because that's what the constitution of India says. But the present government is not prepared. Then recently they attempted a similar case before the Indian Supreme Court, trying to scrap Article 370 and Article 35 in which you can't buy properties in principle inside Valley. And why is that article? Because if you're a student of international law, so 4th Geneva Convention talks about occupation force. If you are an occupation force, let's say in Israel, Israel cannot change the currency of the Palestinians. Israel cannot deport people. Israel cannot do a lot of things because it is viewed as an occupying power over West Bank and Gaza. And occupying power means your title is not confirmed. You haven't claimed the title. The title can't be matured in your favor. So therefore, you need to, as an occupying, you are in occupation. So till such time in occupation, you will not disturb the status quo of the locals. That's what Article 35A of the Indian Constitution is saying. That you can't disturb it. And that is what is being upheld by the Indian Constitution, by the Supreme Court. So another challenge was scrapped by the Indian Supreme Court, thrown out. Yet another judgment comes in which a single bench of Jammu and Kashmir High Court says someone challenges the hoisting of the Jammu and Kashmir flag, flag of the state of Jammu and Kashmir. Because there was a Jammu and Kashmir Flag Hoisting Act which says along with the Union of India flag, you will also hoist the J&K flag, so the Jammu and Kashmir flag. So this man goes to the High Court and says, well, I don't want to flag. And the court says, no, you have to. That's what the law is. The law holds the field. He challenges that before the division bench, which has suspended the judgment. But what I'm saying is, what we need to rely on material that is coming out of India to strengthen our case more than. And apart from that, there's a lot of human rights factors and so on and so forth, violations of international humanitarian law that you can kind of document. So my summary would be that you present legal arguments before the international community and come out with some possible solutions on a creative side and see where things go.
You have a last question.
I'm an entrepreneur working in the oil and gas industry. My question is, 2 sovereign states have signed this agreement, China and Pakistan, CPEC. There was a recent announcement by none other than the Chairman Joint Chiefs of Staff. He said that India is spending almost $500 million to destabilize this project and for insurgency in Balochistan and whatnot. What legal action can we as a state take? The proofs that probably our agencies have to highlight this atrocity that India is going to commit or probably is committed.
Thank you very much. Yeah, that actually doesn't address these issues, but he was pinpointing, he was specific. Normally it's generally worded, you know, we would like the neighboring state should not interfere. But in this particular speech, it was giving details. So which basically means the state is extremely confident of the material it has at its disposal to establish there is a case of intervention, unlawful intervention by a neighboring state. Yadav falls into that category as well. So what should Pakistan do? Pakistan needs to present its case legally before the world. Just by saying in generic terms that interfering so on and so forth would not be enough. I think, for example, 1373 Security Council resolution which says you have to counter terrorism, creates an obligation on all the states. Pakistan could go to the counter-terrorism committee which is established under that and say, look, the state of Pakistan is making all-out efforts to fight terrorism. It has invested in its hardware, it has trained people, it is undertaking police operations, military operations, rangers and FC operations, and laying down the life. But by virtue of this admitted intervention, our ability to fulfill our international obligation has been obstructed. So India needs to be put on notice and so on and suit table. And we could submit all this in our annual report before Counter-Terrorism Committee under 1373. So you document it in United Nations and you say, look, at a responsible state, I'm trying to fight this menace. I'm trying to fight and clear them up. But here's a state whose intervention is obstructing my process. So the way you frame it makes a lot of difference, because then you are framing it in the language of conventions and treaties, which is far better understood in general terms.
Can I now request Mr. Shahidul Khan to